Bill Henshaw here again, Constitutional Crisis Channel, and I have a recent event that you haven't seen in the news, but you should be well aware of what's going on here. I'm going to give you a kind of an alert in case they try this kind of BS on you when you get your turn in one of their damn courts. And that is, my friend out there, in his case, in the damn traffic court, put in all the documents that come from my document packet. And you can get my packets, by the way, request information at ccaspari@live.com, and put in all of the 5 basic documents, which are a bill of particulars, motion to dismiss, brief on the 14th Amendment, notice of denial of counsel, and notice of objection to entry of plea. All of these are well-founded in constitutional law. Any one of them beats the bastards. And to date, especially in California, I've not had any resistance at all, because I run up a record of 7-0 here in traffic courts without any opposition. The charges get meekly dismissed. See you next time. That's how it's supposed to happen. Right now, I'm 9-0 overall. I'm going to be 10-0 the next time I talk to you, because I haven't counted my jaywalking case yet. And maybe 11-0 if we get this case dismissed like it should be. But the scam they're pulling here, I mean, my God, I don't even know if I can describe it on a brief video. But my friend put all these documents in. The local dumbass, or the DA, hasn't opposed any of them. And they've been on file now for over a month. Now, when that happens, and you go into their courts, and they put in motions and notices, and you don't respond, what does the black-robed bastard tell you so condescendingly in their courts? Failure to object timely is fatal. These charges should have been dismissed weeks ago. But we have a written order from the judge, quote unquote, saying that there will be no ruling on any of these issues until we determine the quote unquote competence of the accused. Now, what the hell one has to do with the other, I don't know. And I have a peculiarly strong background with this, because that's what happened to me on my 7-month vacation in that South Carolina jail cell, where they initially tried to pull that scam on me. And I went before one of their strengths a couple of times, and those were actually very pleasant experiences. We laughed, we joked, there wasn't anything about it, and she made the only finding that she could, that I was clearly competent, which they should have known from having read the 150 pages I sent back there initially on a writ of habeas corpus. But it failed there, and it's going to fail in Merced, and if you follow my instructions and do what I tell you to do, it's going to fail if they try to pull it on you. Now, the seriousness of this, in this case, might go right from Merced to the 9-0 farts in Washington, D.C., because if they're going to make a preliminary determination of competence, quote unquote, and have you evaluated by their paid hitman in the form of a shrink, you know, what are they saying here? If you're not competent to put on your own defense, you know, and come in there and take care of business, how can you possibly, among other things, be competent to have voted in an election to elect these bastards to the office they hold? You're either competent or you're not. Further than that, there's also a well-known presumption in law, a presumption of innocence, and a presumption of competence to go along with it. And my friend has it, and none of you should ever willingly put in a plea of not guilty by reason of mental disease or defect. That might make such a proceeding valid. And all they have here, by the way, in California is the Penal Code sections 1367 and 68. But it's so far out in left field. And I wrote a letter to the presiding judge, had just gone off as I'm making these videos, and saying, in effect, what you're doing here is being sure that you can saddle this guy with the public pretender who probably won't even understand the issues, let alone present them in court. And by this ruse, they're going to get around having to answer your questions. And by you having one of their attorneys, you're then going to go up on an appeal, and they're going to say, oh, you had a fair trial. See you later. That's how this crap works. Well, we have a right to do everything that is done in my traffic packets. That bill of particulars, you have a right to know nature and cause of the accusation, identity of the elements of the crime, identity of the injured party, and a whole lot of other astounding facts that they never taught you in their mandatory public education system. Trust me, I never heard it either 50 years ago. I learned it the hard way. But I did learn, and you can too. That's the whole point. But this stuff, like I say, this one might go right from Merced to the Supreme Court, because what they're doing here is, in effect, stripping away all the rights that we had, most particularly prior to the ratification of the non-existent 14th War Amendment, which is even deader in my sights than it ever has been before. That's the only possible justification for it, which is a video for another day. But trust me, that's what it is they're doing. So if they try to pull this on you, you get in touch with me. Because among other things now, I have a couple of documents that you put in addition to the basic documents. And with the notice of denial of counsel, you're saying, in effect, I can't accept counsel because counsel is a licensed attorney who's a paid state agent and is going to be on their side, not mine. And he gives the court jurisdiction if I use him. That's the sort of thing you want to avoid like the plague. But then you have another one and say, okay, you want to get the trial judge to sign a notice of indemnification, and if you do certain things during the course of the proceedings, that he will indemnify you and be sure that the Supreme Court of the United States will not interpret any of that as a stipulation to the jurisdiction of the court. You will not find any trial judge from Bangor, Maine to Portland, Oregon that's going to sign something like that. And yet we would have every right to do that to protect our rights. The Supreme Court itself has said, and I quote, the Constitution gave to every man a right to present his case to the court of the nation, no matter how small the claim, nor how little interest the community in its outcome. The framers of our Constitution thought it important in the interest of justice to create a tribunal superior to influence as possible in which that claim might be decided. That's from a case called Cohen, C-O-H-E-N-S versus Virginia, 6 Wheaton 264, 1819, written by Chief Justice John Marshall, the infallible icon of Harvard and Yale, who was never wrong, was he? You want that whole case, send me an email, ccaspari@live.com. I will send you a copy of that, and I'll send a copy of the excerpt of this exact quotation, and you're going to see that I didn't miss a word there. When I first read that in the stacks of those libraries 25, 30 years ago, when I first read that case, I broke down in tears. That's not what you normally do reading law books. But that's the truth, and it's what they don't want you to know, and it's what they're trying to get around by doing this BS with testing your quote-unquote competency. And oh, by the way, this shrink said in there that there's no way that the subject could put on a legally competent defense. Now, how in the world would a shrink untrained in law know what a competent defense would be? And my friend, and the shrink admits it in his own report, every legal objection he made there was right on point. Maybe not as artful as I would make it, but I have a lot more experience. But you can do the same thing, and without that much study, it won't take you 10,000 hours in 4 decades like it did me. But you use these documents, and this gets you around all this nonsense. And we may actually get a writ of habeas corpus from the Supreme Court to enjoin this across the country so it doesn't happen to anyone else. I'll have more updates on this one later as events develop. Thank you.